Section 47 A and B of the New South Wales Fair Trading Act. Now you might be thinking to yourself, what do I as an agent need to know about Section 47 A and B of the New South Wales Fair Trading Act? And to some extent I would agree with you, because we have our own act. Real estate agents and stock station agents and strata managers, we have our Property and Stock Agents Act 2002, as well as a set of regulations. And in fact, in those regulations, we even have schedules which then give us even more information about how to act and what to do. However, on the 1st of July last year, 2020, in the midst of COVID, in a sense, the New South Wales government amended the Fair Trading Act 1987, and it introduced, amongst other things, Section 47A and Section 47B. Now remember that the Fair Trading Act is a New South Wales Act that deals with consumers and consumer protection as a general comment. So what I'm about to explain to you includes real estate agents, but it isn't directed at real estate agents per se. Why? Because amongst other reasons, we have our own act, or you have your own act, more accurately. But it's important that you understand about Section 47A and B, because it's going to come up in your day-to-day operations. And I'll make a comment early on here that it's principally a backup to what you ought to be doing anyway, and what most of you, I'm sure, already do. It's all about disclosure and treating your clients with commercial respect. And you'll see as I explain things what I mean by that. So my comment is that many of you already do the requirement outlined in these sections, or you are aware of similar requirements in the Property and Stock Agents Act. But nonetheless, let's have a look at it. Okay. So the 1st of July last year, 2020, without much fanfare, the government introduced these amendments. And they relate to consumers and businesses offering goods and services to consumers, which obviously includes real estate agents. And although we do have similar provisions in our Act, in particular a Section 47, which is very similar to Section 47A and B, where ours is Section 47 of the Property and Stock Agents Act, and it has some overlap there. But these two provisions, 47A, relates to making sure that you disclose to your consumer, your client, your customer, any terms and conditions of any service provision, goods or services, that may have a prejudicial impact on them. Now, if you look at the legislation in question carefully, you can see it's really oriented towards very much overtly consumer products. Like let's take the supply of white goods, for example. If you read the legislation carefully, that's probably where it was probably aimed at specifically, but it encompasses all businesses, and so we need to have a look at it. So Section 47A, you must disclose as a business service provider, as a business to a client, whether or not there are any terms and conditions in your service provision, contract, written or oral or combination, that might prejudicially impact on them. Now, what this means for most real estate agents is their agency agreement. Most agents that I'm aware of would use widely available and accepted agency agreements provided by reputable sources. And I don't believe that those agreements would be subject to this sort of concern, because they're so widely used and so carefully prepared with the consumer in mind. But if you have a bespoke agreement, or if you're working in a specialist area and you've had a solicitor or some other professional prepare your agreement for you in compliance with the Property and Stock Agents Act, but not necessarily in compliance with Section 47A of the Fair Trading Act, you should probably have a look at it again. In other words, are there terms and conditions that could be seen as prejudicial to your customer? You would need to be making them aware of it. Now, as I mentioned before, most real estate officers that I'm aware of, or practitioners, would do this anyway. So this is an added precaution in a way. Section 47B of the Fair Trading Act is probably more more relevant, if I can put it that way, because it deals specifically with intermediaries, of which real estate agents are clearly one. And it deals with the need to disclose any referral fees or commissions that you are receiving from a third party. Now, although this particular aspect of referral fees is dealt with in a sales context in Section 47 of the Property and Stock Agents Act, your Act, okay? What Section 47B of this Act does is it broadens the field of capture, because Section 47 of the Property and Stock Agents Act deals specifically with the sale or purchase of land. That section doesn't go further into property management. Whereas this section here says, doesn't matter whether you're an agent or not, if you're an intermediary of some description, which of course agents are, then if you are receiving commissions or referral fees, you must disclose that to your client. And you must be seen as having taken reasonable steps to do so. So, as I mentioned before, although this is to some extent seen as a sleeper, in a sense that it was introduced middle of last year, and it really hasn't taken prominence in the industry's mind as yet. I think it probably will in due course, in particular in respect of Section 47B relating to intermediaries and the need to make disclosures in respect of referral fees. And those referral fees need not necessarily relate to sales. In fact, it's a very broad capture. My name is Craig Swan on behalf of Leverage Academy. I'm hoping that information is useful to you. If you'd like to give me any feedback or comments, I'm always very grateful for that. You can reach me at Instagram, Craig_Leverage Group, or you can reach me through email, craigs@leveragegroup.com.au. As is customary for me, I'm wishing you well in the new year, 2021. Take care of yourself and happy hunting.